G'day everyone, this is Drew here from Munros. Today we're going to be talking about the Protector. It's an asset protection strategy to help protect your family home and your family wealth. And I'm joined here today by Sol, one of our outstanding managers. I'll get him to introduce himself very shortly. Let me just flick on the slides. So asset protection is one of our key pillars here at Munros in servicing our clients. Those key pillars being to help you start, grow, and exit million-dollar, if not multi-million-dollar businesses, legally minimize your taxes along the way, and safeguard your wealth. All in all, what we call experiencing success. So today's really about that safeguarding your wealth. So it being a presentation that we're giving publicly, it's not tailored to your specific circumstances, so it is just general information. So when you do need some tailored advice for your circumstances, please reach out to us and we can help. So disclaimers out the way. So once again, we're talking about the Protector today. And it's really come about, it's really topical at this moment because there's actually a recent court case which has come out. And so we can go and get into this, what I'm going to do is hand over to Sol. Sol can quickly introduce himself and then talk about this case at a high level and then what we can do to protect our wealth. So away you go, Sol.
Thanks for the lovely introduction, Drew, and thank you to all our listeners for joining. I suppose the best way to get started on this case is there was a recent federal court case decision in the Commissioner of Taxation First Bosanac, which shocked the industry. And it's a very sobering reminder that we cannot take asset protection for granted. So what happened within this case is that the court made a judgment against the taxpayer for unpaid taxes, being Mr. Bosanac, and it had established that there was a $4.5 million property that was acquired in his wife's name. And they deemed in the court that that property was held 50-50. Okay, so what that has allowed the tax office to do is, even though this couple has been divorced for 4 years, because of Mr. Bosanac's ATO debt, the tax office has been able to access 50% of his ex-wife's property. And this Protector strategy that we're going to put forward to you today will help you protect your wealth and safeguard it from creditors.
All right, so that's the case there, Sol. So up next, we've got to talk about the actual asset protection strategy, which is called the Protector, and what that actually means. So can you run us through what the steps are and what would be created and such?
Yeah, sure. Great question. So look, Drew, firstly, the Protector is an asset protection strategy. It provides both asset protection and ensures that the assets are held for the beneficiaries of the trust, as well as your family bloodline in the future. What this does is, when it is implemented, it ensures that your hard-earned assets and wealth are kept in the hands of your family, and it protects them from creditors in the case of bankruptcy or divorce. What the Protector involves is the establishment of a special purpose trust known as a leading member trust. And within this trust, what it does is it locks in your family's wealth for the long term.
Okay, so the first step is to create a family protection trust. And then move on. But can I ask you a question, Sol? So we've got a number of clients that have already got trust set up, or we ordinarily set up what's called a discretionary trust, where the family protection trust is slightly different. Is there a necessity to use the family protection trust, or could we use one of these existing trusts, or just simpler, newer trusts?
Yep, so great question. We would advise our clients not to use an existing trust. The reason being is, with an existing trust, you don't know what skeletons lie in the closet, because there could have been a business that was run through that family trust. So if anything happened in the future, there could be a litigation claim made against the family trust. We would advise it's best to set up this clean skin entity, because you know that there's no risk of creditors coming after the trust, suing the trustee. And because you're protecting your wealth, you want to make sure that that's separated from business and any other associated risks. To answer your question with regards to setting up a normal trust versus this leading member discretionary trust, it can be done through a normal trust, but we would advise against it. The reason being is when you set up a leading member discretionary trust, what is written within the deed is there is a hard code writing to say that in the event that the appointer or trustee is in a position to get sued, they go bankrupt, or they're going to be getting divorced or have dementia, they automatically get removed from that role. Now, the reason why that is good is because once they're automatically removed from the role, what will happen is the next person in line will come in and take over their position. So when that person is going through the courts, they're not going to have any assets in their name because they don't control the trust anymore.
Okay, so excellent. So basically, we want to set up that family protection trust. So what are the next steps? What do we need to do to actually have the asset protected?
Okay, so to have the asset protected, it would already be owned in your personal names. We don't want to transfer that asset into the trust because that will create stamp duty and capital gains tax issues. So what we do is we gift the net equity of that asset into the trust. So the trust owns the equity. So let's say, your family home is worth $1 million and you've paid off $500,000 of the mortgage. What we would do is you would be able to gift the remaining $500,000 into this family protection trust. Once the amount is gifted into the family protection trust, that amount then gets lent back to you, and we register a mortgage over that amount on the PPSR. By doing that, what it allows you to do is, if anything happens to you, the family trust has got a mortgage over that equity. So they can call for it to be paid from you, and they will rank before unsecured creditors.
Excellent. Okay, so that's fantastic. But there are some issues around clawback provisions. So do you want to run us through those?
Yep. So whilst these asset protection strategies are great, everyone has to be aware of the bankruptcy clawback provisions. And what these provisions are is, if you transfer an asset out of your name into a related party, if that transaction happened within the last 4 years and the person was solvent when the transaction happened, there is a chance that the trustee under bankruptcy can claw that asset back. So we would advise that it's best to try implement these strategies as soon as possible, because once the 4-year period has elapsed, then that asset is going to be protected indefinitely going forward.
Yeah, sensational. Thanks very much for giving us a quick rundown there of the protector, Sol. So that's the protector, everyone. So a recent court case has highlighted the fact that just because an asset's not in your name doesn't mean your creditors don't have access. And there are ways to mitigate this, but you do need to be acting as early as possible. So if you want some assistance in looking into whether this can suit your circumstances, just reach out to us. And for everyone who may or may not be aware of who Munros are and has just come across this presentation, we're a top 1% ranked Australian accounting firm. If you want to get some confidence in our service quality, I suggest you have a look at our great collection of 5-star reviews as shown on Google. And to reach out to us, you can email us at digital@munros.com.au, give us a phone call, 08 9427 5200. So thanks very much, Sol, and thanks for everyone for sticking around. See ya.
Thank you.